Huh?
I've only ever used the one that you used.
That 50. Well, I've used it before and it used to work fine.
All right. Who are we looking for lawyers? We have a grist and a rupture.
Rupture and grist are.
The lawyers, both of them.
Yes.
Like,
No, rupture is the defendant. Grist is for them, and then 4343 manager is who the plaintiff is.
we have an iPhone. Are you ready? You just gonna do it from by listening?
Yeah.
Y'all are muted.
Good morning.
Are you, Mr. Rupture, you are muted right now.
Yes, sir, I'm here.
We can't see you, but we can hear you. There's somebody on an iPhone. There we go. Do you know who's on the iPhone? Oh. Not you. Right. All right, I think this is 003-1388-2021. And it's 4343 at the Parkway versus Kenneth Repsher. Probably I'll start with who you are and who you represent. Mr. Repsher, I know you're the defendant in the case.
Correct.
Okay. Ms. Dill, who do you represent?
I represent Mr. Rupture.
Okay. And I don't know who's on the iPhone. You're muted.
Good morning, Your Honor.
Do you represent 4343 at the Parkway?
Correct.
And what is your name?
Elizabeth Ashley Clark.
Okay. Are y'all expecting anybody else to join us?
No, Your Honor.
I have a team member.
What was that?
I have a team member of mine as a witness. It did Miranda Carrion, who served the 3-day notice. She's across from me.
He's with you though. We don't need to bring him in on a separate Zoom. Is that right?
No, sir.
Okay. Are y'all ready to go?
Yes, sir.
Okay.
Yes.
The plaintiff may either make a opening statement or call your first witness.
Your Honor, I don't have a witness to call, and Miranda's here in presence if we need to on her relative to questioning with respect to the 30-day notice served at the time. I'd like to proceed with a rebuttal to the argument in the statement when the time's appropriate.
You represent the department, right?
43, if correct.
You're not going to offer any evidence?
I'm sorry.
You're not going to offer any evidence?
I think all of the evidence that we have has been sent to the JP court previously that should be in your documents, I presume.
Well, this is a trial de novo.
Okay,
It starts over.
okay. So perhaps I'm not clear on what documentation you do or do not have. If I need to submit copies of the 30-day notice, lease agreement, that sort of thing, I presume that those transferred.
Well, it's a new trial. I mean, you can offer whatever you wish to offer, but as of right now, I have no evidence of anything.
Okay, I can scan those over to Mindy.
Your Honor, I argue that the plaintiff is not ready to go for trial, and we were requested to submit all exhibits by noon yesterday. The defense is ready to go.
Well, and even if the evidence was submitted, it still has to be offered in a way that could be admissible. So if you don't have any witnesses to prove up your documents, I don't know what you're planning on doing.
Who are you speaking to, Your Honor? Me?
Yes.
Okay, so then at this juncture, I was very much under the presumption we are prepared. I'm prepared to discuss the argument that came through, which is why we're here today. But I very much was under the presumption that the documentation transferred from the JP court to county court. And so perhaps if one of two things, if I'm not in a position based on your decision to scan in the documents that I have to Mindy that were sent previously to the JP court, that would be my inquiry number one. Number two, if we ask for a continuance, we are prepared, but I under the presumption that all prior documentation sent to JP court, and I was not familiar that we start over at the county court. My apologies for lack of understanding, but we're prepared to defend.
Anytime a case is appealed from a JP court to county court, it's a trial de novo. And so you're starting
Okay.
over. You have to offer.
I was unfamiliar.
Yeah. You'd have to offer all the evidence that you intend to offer, and you have to offer in a way that's admissible under the rules of evidence.
Your Honor, since the plaintiff asked for a motion to continue this, I would request that you consider continuing this until Mr. Repsher gets a decision from the Texas rent relief. He has his application in, and we're just waiting on his approval.
Okay.
That's a part of the discussion, counsel.
I didn't know that was going on also. I think if you file an application, you allege that he's entitled to that. He can't be evicted if he's eligible for that relief. So
Your Honor, the defendant had sent an application in or an inquiry with Texas Rent Relief post the judgment. And so that's a part of our discussion today, or our defense, which that's for you to decide, but it was well after the judgment.
Okay.
So one of two things. I'd like an opportunity to take 5 minutes. I'm not sure if there's other cases on this time spot. I just need 5 minutes to scan the couple of documents into Mindy. My apologies for lack of awareness or understanding that documents didn't transfer from JP to the county court. If that's not acceptable, I'd like a continuance by just another couple of days. And independent of council's comment of Texas rent relief, because that application came in well after post judgment. I need about 5 minutes. If we can't accomplish the 5 minutes for me scanning in what I need to Mindy, then perhaps you would bless a couple of days continuance, no more than a week.
I oppose that, Your Honor. Our pleadings specifically state that the plaintiff's application for rental assistance is in process, and it was submitted on March 2nd.
Yeah, here's what happens.
It wasn't, though.
When a appeal from a JP court happens, there's basically there's no judgment anymore. That judgment is no longer final, and it shows up here just as it starts over. It's as if nothing has ever happened before. You have to prove up your entire case. And if there's an allegation that he's involved in the rent relief process, I think the law right now is that we can't do anything with the case until that's resolved. And so what I am going to do, though, is grant a continuance. So give y'all, it'll probably be a couple weeks, though. But he'll have to have time to go through that rent relief process. I don't know how long the application takes, but I don't think under the current law we can do anything with the case while that process is going on. I think that's my understanding of the law. We haven't had a lot of these, haven't had any actually, where someone has filed for the rent relief process. So, but we'll give y'all a couple of weeks to figure it out.
Your Honor, our offices just received.
Go ahead.
Your Honor, our offices were in receipt of an email from Texas Rent Relief last Thursday, April 16th at approximately 5:30 p.m. that Mr. Rebsher had applied for Texas Rent Relief. And at this juncture, we're, almost 6 months into no collection of rent. And so I will kind of counter that we are ready to defend my lack of understanding that we needed to start over with the county court. I very much was under the impression that the JP documents transferred. And so with your blessing, I don't need a couple of weeks, and I'd like an opportunity to defend that Mr. Rebsher had just applied for Texas rent relief.
I think that's okay, though. I think once he applies for rent relief, it's like a stay in a bankruptcy court. You can't do anything with the case until that issue's been resolved. I don't know if that's true or not, but that's my understanding of what the law is. It's a new.
Understood. We have not engaged in Texas rent relief for Mr. Rebsher is where I'm going. We've received an application, but it's to the landlord's business discretion if they participate in Texas rent relief. Is that correct?
I don't think it's an option. I think if someone applies for a rent relief, it stays any eviction proceedings. That's my understanding. I don't know. I haven't had to deal with it at all, like I said, but that's something we need to have figured out before we go forward with the case. But I do know that when the stuff shows up here, you're going to have witnesses to actually admit leases and those types of things.
Okay.
You have to follow the rules of evidence, in other words, once you get up here to proceed. So let's reset it for a couple of weeks. When could we try this? How about Tuesday, May 4th?
Let me just check our calendar, Your Honor, 1 moment.
At 9 a.m.
Your Honor, would Wednesday, May 5th work? May 4th is actually foreclosure day.
Oh, it won't, because we have a big docket that day. I guess we can do it in the afternoon on either day.
Wednesday, May 5th in the afternoon would be preferable.
You want to do like 1 o'clock?
That would be perfect.
Does that work for y'all?
Yes, sir.
And get your witnesses available to prove up any exhibits you might want to offer, because you basically have to start over is how it works. And then if y'all would look into the Rent Relief Act and figure out if we're stuck doing nothing right now or if we can proceed. I'll look into it also.
Yes, sir.
Yes,
Okay.
Your Honor.
you.
See you on then. So it'll be May
Thank you.
5th at 1 o'clock.
Thank you.
Thank y'all.